All right, this We the People news. Okay, never look straight forward. Always look around you to be able to protect yourself by any means necessary. Always challenge jurisdiction of the courts. Always. Okay. Anything I say or do is just my opinion. Okay, no more, no less. I'm not an attorney. I cannot give legal advice. Do your own research. Please do your own research. Use the Second Amendment. Arm yourself with knowledge to be able to protect yourself in these cases. Now, this video, I'm led to believe, about 14 years old. And, I think this was a different YouTube channel and kind of brought it up again. All right. But Pro Se started doing this. Then all of a sudden, this magic word appeared. Sovereign citizen. Sovereign citizen. Now, some people misunderstood it, misimplied it, and all this kind of stuff. But my understanding at the time, I thought they were sovereign citizens. Yuck, disgusting. But when I started reading the law, instead of going by hearsay, they're not so much a sovereign citizens as what the government or attorneys or judges are making them out to be, or cops. All right, they're standing on the Constitution and not statutes. And when you challenge jurisdiction in courts, all you hear from attorneys, well, they just have it. They've magically got powers. And we don't understand how they have it. We just know they have it. Well, there's Supreme Court cases out there, right? And I showed videos of some of them, about jurisdiction issues and by the court case, okay? And they may have general jurisdiction, but that's to establish if the prosecutor or the claimant have subject matter jurisdiction. Which jurisdiction, which standing do they have? And this is where we're stuck at. It is extremely hard, designed on purpose, to get subject matter jurisdiction. Other ones are easier, but it is extremely hard to get the subject matter jurisdiction. Okay? And really, it's not a complicated issue on this. We have rights. Where's the victim? That's all there is. Where's the victim? Who's making the claim? Who's the man or woman? The state is not a victim. Why? Because it never appears in court to make the claim. Now, there's a witness, like Officer Dan, but a witness to what? Because Mr. or Mrs. State of Texas never appeared. And this is where we're kind of getting into that administrative deal, and you have no constitutional rights, right? Why you say that? Because the Sixth Amendment says I have a right to face my accuser, but Mr. or Mrs. State of Texas never showed up. So they violated that Sixth Amendment right. Period. Okay? And administrative is not judicial. Judicial has 11th Amendment sovereign citizen immunity. But magistrates, administrative, does not. They're not actually judges, or if they are judges, once a judge down status themselves into an administrative deal, well, they also gone ahead and waived their judicial immunity. Okay? So we got to understand these things. If you're even going to sue the judges and all this kind of stuff, you got to sue them in the magistrate area, the administrative area, and not the judicial branch, because they have immunity. And that's not where they was operating in. This is the reason why you challenge jurisdiction of the court, right? Is where are they in administrative or are in the judicial? We got to figure that out, Judge. Which one are you? Since you are a judge, but are you in judicial or are you in administrative? Because one has immunity, one don't.
I am Kusha Muriel. Would you state your name for the record, please? Your attribute for the record, please.
Cheyenne Matilda Kusha Muriel on behalf of the Marrakesh Empire Aboriginal Law.
you a couple of questions, please. The first question I want to ask you is, are you employed?
Objection, ma'am. This hearing is supposed to be about jurisdiction. This court has no jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal.
Well, if I have no jurisdiction to determine my own jurisdiction, how are you going to get that issue resolved?
Listen, this case.
And she answered that question. How would they get it? Well, it's because the prosecutor, the claimant, that's how she gets it. Let me breathe. That's how she gets jurisdiction. If the prosecutor or the claimant has standing. All right? The claimant must be there to be able to face it with the Sixth Amendment right. If the claimant's not there, then what? Why do we need a witness? The claimant never appeared, which is really what they're doing in family courts, and this is how they're railroading families and disrupting the whole family system. They're in there just saying they have jurisdiction. But that was a great question from her. But she still never explained how she's got jurisdiction. I'm sitting here explaining.
And this courtroom is a culpable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only having threat, duress, and coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here under threat, duress, and coercion. It is completely against federal case law. It has power to act, and a court must have the authority to decide that question in the first instance. That's Rescue Army versus Municipal Court of Los Angeles. A departure.
Listen and write it down.
By a court from the recognized and established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right. It's an excess of jurisdiction. You have the flag right behind you, ma'am.
May I interrupt you for a moment?
You may not, ma'am. I'll
And would you, when you're done speaking, would you let me know so that I can ask a question?
I'm not obligated to answer any questions, so I have no intentions of answering any question.
I'll ask it anyway, and then I'll ask it anyway, and you can decide what you want to say.
Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term, Dillon versus Dillon. Courts enforcing mere statutes, as it is to my understanding that this is a statute, not a constitutional violation of law. In fact, one of the hearings I had with you, you said people are not charged for constitutional violations. I don't understand how you could be enforcing statutes and you have the Constitution, the U.S. flag behind you, as if you had taken an oath to uphold the Constitution. Courts
There you go, right? Because statutes is administrative. Now that being said, we're going to go back with another case that's never been overturned. Marbury versus Madison. If anything, any law contradicts the Constitution, it's null and void. So you got to actually, above everything else, since you're not going to win doing this route, which I don't know what happened to the end of him, but you got to find out where that statute lies and married with the Constitution and make it available to be there, right? We got statutes saying that you're not allowed to have this type of bang bang, but the Constitution says shall not be infringed. Well, that's in contradictory to the Constitution. That statute is null and void. People, quit listening to hearsay. Do your own research. Attorneys, judges, officers, they're all hearsay. I'm hearsay. Don't listen to me. Do your own research. He's hearsay. Do your own research.
Courts in their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compel the parents. Boswell versus Otis. I've been here 3 or 4 times on the threat, duress, and coercion. Prosecution doesn't even have folders in front of them. He has no objections. He has nothing to say. He cannot prove jurisdiction. This court should have been dismissed this case. This is a colorful court of incompetent jurisdiction.
There he goes, right? Now, I'm going to go a step a little further, right? There is a particular thing in there called silence, acquiescence, and tacit agree to your terms. So why that attorney on the other side, the plaintiff, right, is listening to this guy, he's not doing any objections. So he's actually agreeing to every single thing he is saying, because the attorney over here is in silence, acquiescence, and tacit agreed. Now, the judge is not agreeing to it, but the judge thinks she's got magical powers.
That petitioner was released on the promise to appear before a magistrate for an arraignment. That fact is circumstance to be considered in determining whether the first instance there was a probable cause for the arrest. Monroe versus Popper. There is no discretion to ignore the lack of jurisdiction. Court must prove on record all jurisdiction facts related to the jurisdiction asserted. A universal principle, as old as the law, is that proceedings of a court without jurisdiction are a nullity and its judgment therein without effect either on personal property. This case has already been put before the federal court, and you will be receiving a notice of removal very shortly. This court has no jurisdiction. Prosecution can't prove jurisdiction. This case shall be dismissed, and it will.
Did you file?
You gotta love it, right? Because they can not prove it. And if they can, there again, all the Supreme Court says that must be proven. She has to tell them, how do they have jurisdiction? Not complicated. And I don't care if you're a sovereign citizen, a national, one of the people, however you want to look at all these terms out there and all these people doing their standings and all that. The one thing is in common is that everybody still has a constitutional right. And if it's in conflict with the Constitution, then there is no jurisdiction.
A notice of removal with the federal court?
Yes, you will be receiving it shortly.
All right. When I receive it, I will rule on it. This is my question to you, however. Are you employed?
I'm not employed. I'm not employed with any corporations incorporated with the state of New Jersey.
Are you employed with any corporation that's incorporated outside of the state?
Objection. I'm not here to answer questions about my employment.
And she'll tell you why here in a minute, but this is a curveball, and you'll see what I'm talking about here in a minute. To get jurisdiction.
The last time I was made aware of this was supposed to be about whether this court has jurisdiction, and clearly it doesn't. A question about employment has nothing to do with whether this court has jurisdiction, so I'm not obligated to answer those questions. I shall not be answering any more of those questions that are not pertaining to jurisdictional facts.
Well, this is my question to you. I asked it before. If your position is that this court has no jurisdiction to determine its own jurisdiction.
Listen, objection, man. That is not my ruling. That is not my holding. I've given you the federal case law regarding such. And maybe you can take some time out that you need to do to recheck that. But that's what the case law says, not what I said.
Well, I do have jurisdiction.
Right? Calling her out. Read it. This is what your boss is saying. Back into the deal. How am I supposed to get jurisdiction? Well, you don't. It's the prosecutor, the claimant. It's their standing that has jurisdiction. It's got to have subject matter jurisdiction, personal jurisdiction and all that. They must provide that to the courts, right? She has no jurisdiction in the matter unless the plaintiff and the claimant has the right standing. Then she can hear the case and have it proceed forward. But the prosecutor and the claimant must show jurisdiction.
Over you. Number one, you're here in my courtroom.
Objection, ma'am. You do not have jurisdiction over me. I'm here by way of threat, duress, and coercion. The federal case law stipulates already that compelled appearance warrants and arrest warrants doesn't give a minister acting ministerially and not judicially enforcing their statute's jurisdiction. That's incorrect and false. You do not have jurisdiction because I'm here. You told me before when I was here that you would lock me up if I didn't come, which was threat, arrest, and coercion.
I think that
All right, we're going to go ahead and end it there. Bringing up obvious good points, right? But more of anything else, who's the man or woman making a claim? And I want to face my accuser. How complicated is that? In order to have subject matter jurisdiction, there must be an injured party. Who is the injured party? That's how the courts have jurisdiction. It's because the plaintiff or the claimant gave subject matter to the courts to proceed forward in the hearing. That's not complicated, y'all. These are We the People News. Bye, y'all.